Good evening, everyone. We will now begin the second of our classes in this course. My name is Anand. I am a researcher at CRG, and I am also hosting today's event. So I will speak a few words of introduction and welcome to get today's class started. This course, Reading Refugees and Reading Migration, is a new venture that is begun by CRG, and we are very grateful to our funders, the Rosa Luxemburg Stiftung and the Institute for Human Sciences in Vienna. And we are also doing this in collaboration with various other universities and institutions in India. Today's class, the second in this course, is on statelessness, legal regimes, global protection, and durable solutions. We are very grateful that we have Dr. Parivelan K M with us. Now, I must say that of all the classes that we are going to have during this course, today's class is one to which I was most eagerly looking forward. That one reason for that is my own background and interest in this issue. Another is Dr. Parivelan's expertise in this matter. I must say that when Dr. Parivelan speaks about this issue, he enjoys a unique vantage point. That vantage point is built by his own strong academic background in the subject and also by the rich practical experiences that he gained during his involvement with the UN High Commissioner for Refugees. And therefore, I hope all of us will make best use of his presence amidst us today and in the days to come. I will quickly read a few words of formal introduction about Dr. Parivelan and then request him to carry forward today's class. Dr. Parivelan K M presently serves as the chairperson and associate professor at the Nodal Center of Excellence for Human Rights Education and the Center for Statelessness and Refugee Studies at the School of Law, Rights and Constitutional Governance at the Tata Institute of Social Sciences. Previously, he served at the United Nations Development Programme for facilitating the post-tsunami recovery and at the UN High Commissioner for Refugees, where he facilitated the voluntary repatriation of Sri Lankan refugees as part of the peace process in the country after its civil war. He also served briefly at the Pondicherry Central University in Puducherry and at the Jamia Millia Central University in New Delhi. He is a long-standing member of the Calcutta Research Group, a former participant of our annual winter course, and for several years now, a module tutor in that winter course. I welcome Dr. Parivelan to deliver his lecture and to carry forward today's discussion. Please, sir.
Thank you very much, and my warm greetings to all the participants and the organizing team from CRG. I just want to start with one small disclaimer or a correction that I was actually part of the Nodal Center for Human Rights Education earlier, and apparently later that program was kind of not continued by UGC. Therefore, my last clinging area is with the Center for Statelessness and Refugee Studies. So this is just a small this thing that center is formally now kind of frozen, but we do human rights and related work in our various facets of thing. But formally, that's not continued by UGC. It was a special program which I was earlier affiliated underneath our School of Law, Rights and Constitutional Governance. I just also second caveat or a disclaimer is also slightly the title I have tweaked it to make it very simple. Because for me to say that statelessness, global regime, and durable solutions, these looked a little unrealistic, to cover in this and even to claim so that we have a nearby solution. I thought we will just touch upon the phenomenon, the concept, the theoretical aspects, the overlapping issues on statelessness and refugees, and other arena like asylum seeker, who is an asylum seeker, how do we do refugee status determination, things like that, or IDPs, internally displaced persons versus a refugee. These few things I thought we will definitely touch and have it as a clarificatory session. So therefore, I just kept it as an introduction to statelessness and emerging challenges, but underneath these issues which are there, the introduction, the intricacies, definitional things all could be sort of covered as well in a way. I was happy to hear this invitation. I mean, get this invitation and to see particularly that we have lots of universities and college faculty members, and it's a great opportunity to interact. I was thinking that we need to mainstream the subject on statelessness, which is very much a kind of underplayed or a kind of marginalized within the discourse of forced migration itself. So I thought it's an opportunity. So it will be more of a conversation, more of action with you all. This is kind of a thing. So to start with, statelessness, we will come to that, of course, defining who is a stateless person, what are the definition. I just wanted to say, start from a legal framework, international law framework, that there are two conventions which deals with statelessness. But later in the end, I also want to kind of deconstruct by saying that just from a legal lens, this issue cannot be addressed. It essentially requires a kind of multidisciplinary or interdisciplinary approach. So that's going to be a kind of thing as well. I'll come to the definition. These are two international legal instruments which are available to define statelessness and all that. Okay, so this is going to be an outline in terms of touching upon what is statelessness as a concept, as a phenomenon, and is it a new, is it a old one? Why does not gain much attention for a very long time, excepting that in the recent years we are talking about it, and then practically we see a lot of relevance now in our contemporary, nature of state, the changing nature of state. I would say that we have enormous transformation occurring with the current political dispensation. Therefore, this issue becomes all the more very important. That how do we understand, how do we address it, how do we interface the international legal regime which is prevailing, the laws which are there, how do we contextualize to our national laws and policies and practices, something which we need to do. We will do it in an exercise, of course, about statelessness. There are also related terminologies like refugees, IDPs, asylum seekers, all that we keep using as a very closely related or sometimes overlapping, sometimes very as a distinct phenomena we look at it. I also would like to do the contextualization in our South Asian kind of history, in our culture, our colonial experience, migratory patterns during the colonial period, post-colonial period, state succession, and how did we create our citizenship laws? What kind of practices are there on birth registration? These are all little issues related to statelessness. We will keep all these as a context, and then we look at how this phenomenon could be approached, what methodologies we could adapt to conduct more research, what kind of collaborative exercise we can do with government, civil society, media, and various other relevant stakeholders. These are some of the things which I will use it as an outline, and it will be also not very organized, very random, even though I have just listed them in a very way. Now to start with, I just wanted to ask the participants, can anyone tell me, from your understanding, what is the fundamental difference between a stateless person and a refugee? Anybody?
Yes, sir, I can say. Hello, sir. Good evening. Statelessness basically means when someone lacks nationality or citizenship, and refugee means when someone is under threat of persecution. When someone feels threatened, or someone feels to be persecuted, or due to war or something like that, so they flee to some other country.
Some other country. Okay, that's good. Yeah. That's very important. So somebody is persecuted, crosses an international border, we call that person as a refugee. Somebody who can be, stripped of their nationality or citizenship within the country, or after that they even flee they could be considered. So by law, if somebody denied of their nationality is a stateless person, in a simpler way to understand it first, yes. All right, thank you very much. And somebody can tell me the difference between a refugee and IDP, internally displaced person. Anybody else would like to volunteer?
Hello, sir.
Yes, please.
IDPs, internally displaced persons. That means he is out of his home, but within the country, actually boundary.
Yeah.
And refugees who has crossed the border, international border, in search of shelter. That is the main difference.
Right, right. Very fair enough. Yeah, thank you for that. Yes, so the process may be similar in terms of persecution, human rights violations, and other forms of forced displacement. But an internally displaced person is somebody who remains within the territory, but moves from one place of habitation, original habitation, to another place. But whereas a refugee moves out clearly, he or she, from their very country itself to another country to seek protection. So that makes a fundamental difference between a refugee and an IDP. Yes, fair enough. And any difference between an asylum seeker and a refugee?
Yes, sir, there is a difference. Asylum seeker is one who has come to a foreign country in search of safe shelter. So anyone cross the border and come to the neighboring country in search of shelter is asylum seeker. But refugee is a particular status that is assigned by the UNHCR. So all refugees are asylum seekers, but all asylum seekers are not refugees.
Very good, fantastic. I think that's very well, explained that an asylum seeker is somebody who could come and seek asylum only if they're granted asylum. Then either they become citizen directly or they can get a refugee status as well. So there is something called an instrument called refugee status determination, which is there. It's not essentially always an UNHCR mandated, but it could be also, a country also could have its own asylum processing system, and there are differences which emerges from a refugee signatory country to a non-refugee signatory country, and all that stuff makes the difference. So in a country like India, where we are not signatory formally to the 51 Convention on the Status of Refugees, here we go by the UNHCR support, UNHCR RSD process. Whereas in some countries, it could be that concerned country could even appoint a civil society, to handle it, or they could directly have an immigration division to handle it and all that. So I think it is very important that we understand these terms. Very, very importantly, you have for statelessness the 54 Convention and 61 Convention, which will come a little more in detail later. So these are two international conventions which are there for refugees. We have the 1951 Convention. We want to have, I think, in the next lecture, a detailed discussion by Professor Sabyasachi Basure Chaudhary on that. So 51 Convention is one of the important landmark ones, the post-World War II, which evolved to kind of provide a kind of international protection norms prescribed by defining a refugee to what are the range of rights which can be secured for a refugee. All are there in 51 Convention and in the 67 Protocol. For internally displaced persons, for a long time we had only the UN Convention on UN Convention on IDPs, kind of more of guiding principles. We can say UN guiding principles on IDPs for a long. And after the Kampala Convention, that has kind of become also a very formal norm which can be adopted. After the African Union had adopted it, it has become a kind of a legal instrument as well, and many countries would do so. And in India, again, we have right from the debates of IDPs, we have a lot of resistance to it, and we have not taken it in a big way. And finally, the Asylum Seeker Policy is also kind of an instrument where you need to formally legislate and formally have a framework on which you have an uniform asylum policy and all that, which again, we lack it. We go by a random process. We don't have a clear-cut asylum policy in our country. So this makes it also quite complex. Very many categories we mingle, intermingle, and then treat them. To give an example, if you look at the Sri Lankan refugees who are here for quite some time, since 1983, ethnic conflict which unfolded in Sri Lanka. You have the Sri Lankan refugees who are here in India. Now, along with them, there are a section of people who happen to be the Indian origin Tamils who worked in plantation, had nothing to do with the ethnic conflict of north and east of Sri Lanka, also started fleeing, and then they also mingled with them, and then they also came along. Whereas we could not distinguish it, we did not wish to distinguish. We sent all of them to a refugee camp, and in a refugee camp, you have a Sri Lankan national, Sri Lankan Tamil, who is also living as a refugee. These Indian origin Tamils were supposed to be treated through a separate norm, because we had something called Sastri Bandaranaike Pact, for example, to address the statelessness in Sri Lanka. India and Sri Lanka went into a series of dialogues, and we had a kind of a formal bilateral treaty. And the Sastri Bandaranaike, Sastri, our Indian Prime Minister, and Bandaranaike, Sri Lanka's earlier Prime Minister, signed together. Later, it also was called as the Indira Bandaranaike Pact in 1974. It went on till 84. And in 84, it formally closed. So by this formula, we were supposed to take 2/3 of the 1 million population, and 1/3 is supposed to be in Sri Lanka, given formal citizenship. Now, these people also, some of them got delayed with a variety of reasons. They were signing for it, and they were supposed to come and get a formal citizenship back in India. When ethnic conflict unfolded, this issue got diluted, and then these people who legitimately were supposed to come and become refugees were also sent to the refugee camp. That's what I mean, that these people who are supposed to be returnees, who are Indian origin plantation workers under a different treaty, now got mixed up. And then you open the gates for refugees, and then then they all went to various refugee camps. They sent a lot of applications and claimed, I believe, but the government and the official bodies kept denying them for a very long time. And then, now there is one judgment, which I can come a little later from the Madurai bench of, Madras High Court. A judgment has been Ulaganathan case, it is called. And that case has kind of opened the door that if these people have an Indian origin status, then why they should not be treated different from the Sri Lankan Tamil refugees and given. Even to categorize them, address them, it's quite complex, quite difficult. The people who implement these policies, the rehabilitation department, the revenue officials who handle the refugee camp, none of them are clear, none of them are interested in all this distinction category. Therefore, I thought it's an important endeavor in our session that we distinguish very clearly who is a refugee, who is a stateless person, and then yet see where are the areas it can blur and that can overlap and all that. The other classic example is, the Rohingyas from Myanmar, that they are denied in the first place, citizenship. Therefore, we can call them as stateless people. And then if they are fleeing from the country to other countries, whether it's Bangladesh or the neighboring Indonesia, Malaysia, or to India, that the fact that they've crossed the borders, they would definitely qualify as stateless refugees. They are stateless in the first place, and then they become also stateless refugees in another country. Had they remained in their own country, there would have been IDP, they would have been just, stateless people. So I think this is very important for academic community also to gain clarity and then address these things in a very careful manner. We know in media, even by a disaster, natural disaster, that people are affected and displaced from one place to another, the media writes them as disaster refugees, flood refugees, or I have seen earlier. We had seen earlier words like tsunami refugees, earthquake refugees. All these are used, and we know very clearly that an official political international law definition, a refugee is a person who flees from one country to another country. If they come from another country alone, they will qualify to be refugees. For quite some time, we had used the word blue refugees in the Northeast, for example. They were only displaced from one place to another, and we kept using the word blue refugees for a long time. So officially, probably we need to kind of make these kind of changes, which are definitional issues, which are very important. And of course, the colonial and South Asian history culture becomes very important because things are quite interconnected, intertwined. When I'm talking about distinguishing the Sri Lankan Tamils and the Indian origin Tamils were called as quote unquote hill country Tamils, Malayaga Tamils in Tamil. So Malayaga Tamils literally mean hill country, meaning that they are working in the plantation gardens of tea, rubber, and coffee estates that they are serving. So they are gone as a kind of a migrant indentured labor and being subjected to work there. And then when Sri Lanka attained its independence in 1948, the first stroke the Sri Lankan new political regime did is that they sort of stripped their citizenship and said that you all now return to India. That's where the crisis actually started as a different issue, which is distinct from the ethnic conflict much later in the 80s. Of course, in the 50s, the ethnic conflicts did trigger in terms of tensions between the Tamils and Sinhalese, but very clearly the 1983 riots and other things, became an important turning point where the refugees formally started coming in. So, we need to kind of, go and address these intricacies and interrelated things, which are very important to South Asian culture, where I would like to invoke, eminent sociologist T.K. Oman's, nutshell definition of ethnicity, which I always liked it. He tried to say that ethnicity is a product of incongruity, a product or incongruity between politics and culture. So the culture, the diversity, ethnic identities which we have are not very clearly manifested in our nation state formation, not clearly manifested in our constitutional process. And we simply seem to adopt it in South Asia as a post-colonial, process, a kind of a, Westphalian model of nation state, which is more of an European one nation, one culture kind of a model, got into this kind of multi-ethnic, multi-religious, multi-linguistic kind of societies which we have. These keeps, revisiting us. This keeps re-emerging, and then that's where we kind of have border issues, and then we have other challenges which we are now trying to address them under the broader gambit of reading refugees, reading migration, or a larger gambit of forced migration and things like that. So a few examples I started quoting already. The hill country Tamils. We also had for a very long time, somebody called West Pakistan refugees, and in the last few years, particularly when a kind of a sudden Jammu and Kashmir reorganization process happened. That is the time where we kind of heard about them more. And then there is a claim now that, with the scrapping of Article 370 and 35A, you have the special status of J&K has been removed, and then thereby the barrier also is removed. But interestingly, this group has been living here right from the partition times. When partition occurred, the larger migration on the east and west occurred. You had these people who were called West Pakistani refugees came in and then moved up for some reasons to Jammu and Kashmir and squatted there, thinking that they are also going to get, like any other people who had been victims of migration movement, that they are going to get. But unfortunately, the special laws which prevailed in J&K did not provide the status. So they kind of remain a kind of a de facto, or you can say even de jure, stateless for a very, very long time. And that is where, a few years back, at least 4 or 5 years back, we did some kind of a snapshot study on them. And then they are almost a couple of lakh people who kind of could not, get a formal accommodation into the J&K, nor move anywhere else. Looking at the poor social, economic, vulnerable conditions, they remained there and could not avail education, could not avail livelihoods, could not get any formal employment. With a tremendous kind of more mobilization, pressure put forth, the center came forward a few years back, and I believe you even recognized them as formal citizens from the center's point of view. But they need to be located in J&K, and J&K and union government, incongruity or the laws which were not in line with thing which went as an impediment for a very long time. That's how they've been denied of their rights for a very long time. What we heard is from our studies that many of them could not avail formal education, and housing and things like that were an issue for them. And because of that, hardly few of them would be able to qualify to some of the central government employments. Central government recognized them, but the state did not recognize and provide any jobs. That's where they had a kind of conundrum and challenge for a very, very long time. The post reorganization, we are yet to do any study, then we are into COVID as well now. So we have not got any clear picture, but there are indications and some things that they are now getting formally their accommodation, and they are now going to be a full-fledged citizens, shifting from their de facto status to more of a de jure status of citizenship and all that stuff we are here. The other example can be slightly again cross-border. Those who migrated from the Indian side of Bihar wanted to go to Bangladesh, Pakistan, but used the channel of then East Pakistan, who got stranded in the outskirts of Dhaka, remained as a stateless group, which is a classic example in South Asia, that they migrated, but they could not reach where they wanted to reach. Again, they got entangled in the 1971 conflict, and subsequently been all the more targeted for siding with West Pakistan. And when the Bangladesh formation happened, they were sort of denied of their rights for quite some time, and accepting that in the recent years, the Supreme Court of Bangladesh has come in a very positive way and formally granted them citizenship. And in practice, we were told that they are still, not having that. Some visuals of the hill country Tamils, who are called the Indian origin Tamils, in the plantation gardens. Just was looking at visuals from the Google Getty images and got them. West Pakistan refugees who went on protesting for a very long time. Some years back, this visual just out from the net. I was just thinking that if it is feasible, whether we could sort of have a small 2-minute thing on the Urdu-speaking Biharis. I hope it works. Let me just test it.
This camp since 1971, when she was 7. It's been a long, arduous journey since then. Now she has several grandchildren and wants them to have a better life than she has had.
We face manifold problems: unclean water, limited space, frequent electricity cuts, and so on. It's very hard for us to sleep, eat, and live in such a small place. You can't possibly stay healthy in such an environment. There are 7 of us who share this room, which barely can accommodate 2 people.
This camp is one of 70 in Bangladesh. It has just 1 school. Conditions are dire in this camp. Nearly 24 in an area smaller than the size of a football field. Houses are separated by a distance of 1 meter wide passageway used by residents and livestock. These small spaces are home to entire families with very limited access to basic services. Recently, Biharis were in the news when dozens of people were injured in a fight between police and camp residents. The violence was triggered when authorities tried to cut the electricity supply. There were protests in the camp for several days. I went to my workshop to get some work done during the fighting with the police. Suddenly, some stray shotgun pellets hit all over my body and one of my eyes, from which I can't see anymore. Most of those living in the camp get no help from the authorities and create their own jobs, but they also face constant threats of evictions.
And now the Biharis are facing challenges like camp evictions and the passport. The authorities said the Biharis are citizens of Bangladesh according to 2008 court judgment. So they are no more stateless or refugees. So why they are occupying the government land or the private land? So the government is trying to evict the camps without any notice or without any settlement.
But where would the Biharis go? The government is considering relocating those living in the capital Dhaka to a new settlement. But 300,000 people spanning multiple generations fear they'll continue to face discrimination. Tanvir Chaudhary, Al Jazeera, Dhaka, Bangladesh.
But just brief glimpse about this Urdu-speaking Biharis. Of course, we all are now familiar with a variety of news and information with Rohingyas who are now, of course, very prominently there. But I just thought, a good friend, this Khalid Hussain, has even another couple of documentaries as well made, which can be useful. I'll show the link in the end. We can, some of you interested can visit it later. Now we know that there are several important changes which are influencing the global arena, which has an impact on the forced migration phenomenon and a variety of classifications and groups as well. 9/11 alone had changed a lot of security paradigm at the global level. So nation states have started making very rigid very rigid thing by closing the borders and things like that. The West Asian crisis, where the post-Arab Spring thing and the Syrian conflict alone had tremendous impact on both refugees, IDPs, and the stateless population as well. When you look at now, besides Syria, you have Central African Republic, South Sudan, Yemen, Myanmar, to name a few, are part of the flashpoints which continue to impact the thing. This is an important slide which will glimpse, of course, drawn from UNHCR statistics on the forced migration. Today, there's almost forced migration numbers have touched around 82.5 million people, which is very high in numbers. It was in the 50 million or 60 million just a few years back. In the last few years alone, it had picked up. Refugees constitute almost 26.4 million. IDPs with official numbers available with UN bodies alone are around 48 million as forced migration victims. If you have to bring in development inducement, disaster inducement, the numbers could be several fold or threefold of this. The stateless population, we may see in the statistics almost 10 million, 12 million or so it has been mentioned, but officially UNHCR had gathered from around the country official statistics. They have only 4.2. These are again can be double or triple of these numbers, which this is in itself is a gap that how many number of stateless population depends on what kind of statistics, what kind of research, what kind of mapping exercise is carried out. I think that is one important gap which we must see. And then we have the asylum seekers is around 4.1 million. So, asylum seekers again are the official numbers which UNHCR, UN body gathers on what kind of numbers people are available, what based on that goes on. So this is, kind of an indicator how in the last few years, this number is been escalating quite in large numbers. When we look at, especially, in a refugee perspective, nearly 68% are from very, countries which are regular in this conflict. Syria, 6.7 million. You have Venezuela, almost 4 million, plus Afghanistan, 2.6, South Sudan, 2.2, Myanmar, 1.1 million. Almost, 39% of these refugees are hosted in just these 5 countries: Turkey, Colombia, Pakistan, Uganda, Germany. Nearly about 86% of them are hosted in developing countries or underdeveloped countries. 73% are quite in the neighborhoods that they are being hosted. India's refugee thing, in spite of being signatory, we have a number of them, right from the in the 11th century, the Zoroastrians, Jews are recorded to have formally come to India. We have partition refugees, Tibetans, Sri Lankans, Burmese, East Pakistan refugees, the Chittagong Hill Tract people, Rohingyas, Somalis, Sudanese, Nigerians. This is the number of, roughly about 2 lakh when you look at what are assisted by the government of India and UNHCR together. It's not a very big number. It's ranging between 2 to 3 lakhs maximum. So this is how, we have about the refugee scenario, the global level and at the national level, how we look at it. Now, what I just wanted to emphasize is, now, and at least underneath the refugee discourse, we have some visible understanding who are refugees, and the 51 Convention, 67 Protocol, non-signatory. Anyway, we have group of people who have been hosted, taken care. In the words of Professor Chimney, that we have been doing good care, where he says that we have had a kind of a charity approach for a long time. And he emphasizes that we have to shift from the charity approach to more of a legal approach in handling refugees. But there are other scholars and other practitioners who believe that it's not just about the legality, but we need to look at a number of other things which goes underneath it. So one pauses and looks at even the present COVID scenario. One wonders actually that even if you are not a refugee, you are not a stateless person, even if you are a citizen, are you adequately protected? Are you adequately taken care? Do you have a proper health access? Do you have proper livelihood access? Do you have educational access? So that is a big question mark that, how we are governing, how we are taking care of our citizens as well. But that does not make it as a burden to exclude, as some of the people with so-called nationalist perspective would argue, that when we have our own problem, we do not want to have ourselves burdened with these new categories. But the point is that we always have had the notions of care, compassion, empathy throughout our history, and this nation state formation alone has made us now to become narrow, and all the more the recent developments globally across has brought in a kind of a perspective that we would like to close the doors and not to have any kind of humanitarian concern. Right away, we know that besides other category of people in different shades, in different levels, if you look at the Rohingyas alone, that we seem to be having some kind of a discomfort. For last few years, we have never heard officially about Rohingyas, even though Rohingyas were here very much being persecuted right at in 2011-12 onwards. They have been kind of coming in small numbers, probably in the recent years. They've come in, accepting that when our Ministry of Home Affairs woke up and suddenly said that more than 40,000 people have illegally entered, and all of them are illegal migrants, and then they are a security threat, quote unquote. And that's how we came to know that big numbers. Whereas the UNHCR feels that they are not more than 15 or 16,000 people who are living, entered and living in various parts of India, Delhi, Hyderabad, even in some outskirts of Chennai, to up to some portions of Jammu and all that, and probably in Kolkata, outskirts of Kolkata, like that, they are scattered around. And how did they suddenly become a security threat? So there we come to know a kind of, and kind of an othering process, who are already been heavily persecuted, been badly affected. Instead of bringing them on board and providing a humanitarian support in a formal sense, we are talking about the numbers and we are talking about expulsion. That's where the matter had to go to the court, and the court, rightly, in the words of former Chief Justice of India, Justice Mishra, had used the right word, that we need to balance between our national interest, national security, and human rights and humanitarianism. I think that puts in a nutshell of how judiciary kind of becomes a kind of a last resort, a savior to kind of bring in some kind of a balance, but the issue isn't resolved yet. So when there were discussions, there were lawyer friends like Colin Gonzalez, Mr. Ravi, and others who were kind of dealing with this process, kind of raised the issue in the courts that, what kind of litigation, what kind of criminal cases we have against Rohingyas. There were actually none. There were no clear case of any criminal cases or any offenses or anything of that sort. Only the presentation was that they are so vulnerable that they can be potentially used as terrorists by outside sources. That's the only kind of thing which was presented. So it all looked at as speculation. It is because precisely that we don't have a very clear-cut law. In that sense, we feel that there has to be some kind of a legislation, some kind of a human rights international standards oriented framework, which ought to have been there, and that would have been at least a legal resort. Otherwise, there's a pressure. Then there is also a question of deportation. There are some who are allegedly being also sent to the borders and been pushed outside the border, where Bangladesh did not even want to take them again from the Indian side. And that's where we saw a clear case of a few families consisting of children literally being in the no man's land and suffered for a few days. And then our border security force then slowly took one by a few of them and started providing them water. And so these kind of crises are there in the borders which do not get reported. Therefore, then one have to delve into the thing. So we are now going to look at with the larger phenomenon of forced migration constituting various categories. We will look at statelessness alone. Now, as said by our friends earlier in the group, somebody who is denied of nationality, citizenship, precisely in the 1954 convention. Mind you that the 1954 convention was also supposed to be along with the 1951 convention in the post-World Wars that they were trying to formulate. And for some reasons, the Statelessness Convention was set up as a separate one a couple of years later, whereas the 51 convention for refugees emerged earlier. But at the time, they saw the closeness between the refugees and statelessness. That's why they are trying to evolve this at the international forums. Anyway, it has come as a separately a 54 convention exclusive of statelessness, and it defines stateless person as someone who is considered as a national, who is not considered as a national by any state under the operation of its law. So meaning that from a nation state perspective, that under the operation of its law, that legally they exclude. So therefore, the de jure nature of statelessness is where the convention is trying to kind of look at it. But we have various shades, various gray areas again between the de facto statelessness, meaning the practicalness of stateless person. A person is exercising, as we looked at the West Pakistan refugees in J&K as an example, that they were lingering between the legal and practical, the gaps in the laws and conflict of law between the union government and the special laws which prevailed in J&K earlier. And one can have all these as a context. So by legal definition, one may look at it, but there are also practical dimensions which we may have to see. The convention provides certain minimum important standards of treatment, what a stateless person may want to enjoy. There is also statelessness, reduction of statelessness convention, again adopted in 61, re-emphasizing that what are the obligations of nation states and other parties where they have to address it and reduce statelessness. But these two never had any kind of reverberation, any kind of an influence or impact for a very, very long time in the academic discourses or in practical issues, excepting that in the last few years that it started gaining momentum. And then precisely outside our borders, we saw these kind of examples. Within our borders, we saw certain groups which were not being studied, as I talked about the hill country Tamils among the Sri Lankan refugees, the West Pakistani refugees. And one may also see these kind of emerging situation post NRC, National Register of Citizens process in Assam. And one would like to see what way it is going to emerge and what are the ways in which we will address it. So how do people become stateless? It can be a number of reasons. There can be causations such as discrimination in the nationality laws itself, that one may have racial, religious, or gender discriminatory law. There can be conflict and gaps in the nationality laws you may have, or the state succession, which we had experienced in the form of a partition, can be a reason. There could be undocumentation as a reason. Lack of birth registration for children can be a reason. For right away, when we look at some of these Sri Lankan refugees, Tibetans, and others who are there, even though they are kind of given as a special status as refugees, we don't have a formal refugee status. But yet a Sri Lankan, for example, Sri Lankan living in a camp would have a Sri Lankan refugee card. Now the children, what happens, in terms of birth registration? I think it was for quite some time, left as a blank, that they did not have Aadhaar card. Therefore, they did not, even in the pre-Aadhaar times, that their birth was not formally registered. But I think with the long campaign and other things, now I think that the father name, mother name, and the names are registered, and a temporary certificate they get, which gets later on formalized with the Deputy High Commission of Sri Lankan Deputy High Commission, located at Chennai. I think grants these things, and particularly when they have to leave the country, they need formal papers. These are all formalized. But it becomes a question mark for other groups who are not formally yet recognized. For example, Rohingya children. What happened? Some of the friends from Save the Children and other organizations who work very closely at Hyderabad and other thing, when we talk to them, it is only through a special campaign that they get them Aadhaar card, they get them these kind of registration. But otherwise, if these births happens at their homes, that whatever temporary shelter, temporary homes, then again, it becomes very difficult. So one may look at from this angle as well, that what happens to unrecognized refugees in India and the children born here is a matter of a great concern, which we may have to look at it. But the Child Rights Convention does emphasize that every child born in the respective places have right to kind of registration, right to a kind of being established. So here again, the matter becomes very tricky on which land, which country the child is now being born after displacement, after all that, where they are born. And then you have the just Sanjini's principle, or is it the just Soli principle? It matters whether they're born in a soil that you are getting it, or is it through descent that you get your birth registry. That matters in a way. The risk of statelessness can also emerge from other displacements, very protracted conflict, like Syrian conflict, one may look at it. It could also be due to gender discrimination in a country where the conflict has taken place. That if even including our neighboring Nepal, I think has this gaps in the nationality law vis-a-vis gender, where a Nepali woman married to a foreigner, and if they are separated, now she cannot now transfer as a citizen of Nepal without a formal Nepali citizen as a male member, partner, or husband cannot now transfer her citizenship, or her property or other rights cannot be transferred. If these kind of challenges are there in some 21 countries. I think in the last few years, UNHCR I think has campaigned in few countries, and I think 4 or 5 I think are made a kind of gender neutral laws. But I think still there are some countries where this issue needs to be addressed. So what are the consequences if you become stateless? So what happens? So without a nationality, you don't access a range of social, economic rights such as education, employment, social welfare, housing, healthcare. All this could be denied, as well as your civil political rights, your freedom of movement, freedom from arbitrary arrest or detention, political participation. All these could be quite a challenging aspect. So what is the legal framework to address it? You have the 2 conventions which are there, and you need to have your citizenship law and other things which have to be in tune. So the states have to kind of address that there are, these are important issues as a kind of a continuum between citizenship and statelessness and citizenship are very interlinked, and this has to be recognized. Then only you will be able to have some amount of thing which in line with the international law. The 54 Convention is in a way seen as a cornerstone for international protection regime for stateless persons. It provides the definition, it provides the minimum standards and what kind of treatment they can have. These includes, but are not limited to, right to education, employment, housing, and other basic rights which have to be there. It also emphasizes the right to identity, right to belonging, travel documents, and other administrative assistance. One may also see this scenario emerging, and might have read in the newspaper that you have in the India-Pakistan side of it, you have in the state of Rajasthan, the Beals, the Beals community keep, I think, they come from the Pakistani side to Indian side, and then they go without any identity for quite some time, because they renounce, even if they've had Pakistan citizenship via their passport or something like that, they just get rid of them and then end up becoming a kind of a stateless, neither here nor there. So these were the communities which were very nomadic, which kept moving around, and some of the partitions and subsequent wars between India and Pakistan reminded them that it is actually no more border free, and it's actually kind of quite rigid. That's where they settle respectively. But some of them keep channeling using this pilgrimage routes, and they come to Indian side and then they claim. So recently it is seen that our CAA is kind of helping them because they claim that they are persecuted, and therefore that's what it is seen as a kind of how they can claim this thing. That's how this one example one may look at it, and yet it remains the CAA as a larger disputed act and bill, which needs to be introspected whether it passes through the constitutional guarantees of right to equality, remains still unsettled. One looks at it in that way, but yet so these conventions are in that sense providing a very interesting framework. So we all know that the nationality as the word being used is seen interchangeably with the term citizenship, which we all understand quite well, and yet there are there could be theoretical, conceptual differences between the term nationality and citizenship. Yet one sees them as interchangeable words. So in a way that one sees nationality for all the basic rights, and the stateless person becomes the most vulnerable, because as in the words of the citizenship becomes the right to have rights, as we all know, an ardent famous quote of right to have rights. So therefore the denial of it could deny all your basic other rights. One may look at it from that lens. One may look at it, the phenomenon of statelessness, if it is denial of nationality, citizenship, on a range of other rights have been denied. Therefore, it becomes very important to re-invoke the very basic instrument, that is Universal Declaration of Human Rights. The Article 15 emphasizes on the right to nationality. Then there are other conventions also which keep referring, besides the Statelessness Conventions, which talk about this basic right. So UDHR as a whole was motivated importantly by the kind of atrocities and disturbances which happened during the World War II, where there were mass denationalizations and huge population movements occurred here and there. There were hundreds and thousands of Jews who survived the Nazi perpetuated genocide, fled their home countries, and then there were also others. Millions of other ethnic Germans were expelled from the East European countries. Millions of Poles, Ukrainians, Belarusians, another minority population in the Soviet Union were either forcefully expelled or fled for their safety. So that huge movement actually created the need, as I was mentioning earlier, right away at the 1951 convention itself. There was a talk to club the statelessness, but they thought that they will have two separate conventions to address exclusively refugees as a separate and statelessness as another issue. That's how we are right from UDHR we have it. So as we said earlier, just to again have a cursory look, the statelessness can emerge or could be triggered due to simply a state may cease to exist, or it can disintegrate, leaving the flight to the successor states, USSR, from a Yugoslavia, or from a unified India to India and Pakistan. Earlier, all could be this example. Political considerations may dictate the way that they are treated or how citizenship laws are applied. As we said, the hill country Tamils right away at 1948-49 itself, they faced the heat of this enfranchisement. And similarly, the Urdu-speaking Biharis who had wanted to go to West Pakistan, but ended up being in Dhaka, Bangladesh for a very long time, from 50s till almost 90s, were denied of their rights in a formal sense. Today, you have Rohingyas in the last 2 decades have been victims of persecution, which keep constantly moving, we said earlier. There could be ethnic minority discrimination. There may be groups living in frontier areas, as we talked about. Community Bills, as a group who frequently cross borders can be taken as an example. There are individuals who become stateless due to personal circumstances rather than persecution. It's about renunciation of one nationality to seek another. When you don't have a dual citizenship, it becomes much more complex. It can be an example. Statelessness can arise between the legal differences between countries. It can also be a failure to register birth of a child. And last, but not the final category, but there could be other reasons. But not the least, that one may even talk about the climate change, the small islands submerging, and all these as a potential thing which could create tensions. Right away, we have in India the Sundarbans region, always triggers India, Bangladesh, India migration movement, which we have been witnessing in different names, different ways we are looking at it. You have Maldives and other Manattua Island, all that in the Southwest Pacific, all could be examples of potential statelessness. So statelessness and citizenship can be seen as a continuum where there is a close relationship, and the othering process in citizenship, where you are invoking some forms of discriminations and other insensitivity, could lead to people becoming stateless. Right away, if you look at the NRC process, for example, we did conduct one small study as well. There are several dimensions of gender, child rights, and several other reasons which could be built in this process. How there was essential exclusion that the administrative processes did not take into account. They looked at more of an administrative legal process, tried to do it. One looks at it very closely. One can see these othering processes where these many people at the time, initially 40 lakh, later on around 19 lakh people, where said that they are not qualified to become one, but they can appeal in tribunals, foreigners tribunal, and other court process. We knew that for several years they will linger without a formal citizenship, and they will have to carry the identity of being stateless. And when you have a situation where the Bangladesh neighboring country also makes it a very clear stand that they will not accept anybody who are pushed out of this NRC process back into Bangladesh. This is a very clear-cut case again. No two nation states taking a position and clearly allowing a kind of a stateless situation. So this is where we call as a classic example of othering process insensitivity, rather than some roadmap to see how you address it. But, anyway. So we said earlier about Jews solely being born in a soil, they get automatically. United States is an example where even if you are on a travel for a short period, if a child is born to you, that automatically your child can get that kind of a automatic thing of being born in a soil. Whereas Jewish sanguinis principle is based on your descent, blood ties, as it is said, that is basically on that. So you have to formally register that even if you have gone to the United States, you are delivering a child, and you have to have an option that you have to go to Indian embassy, the High Commission, and then formally you need to register the birth of a child within a given period of 1 year or so that then when you come back, then you get. Otherwise, it also gets into difficulty. So these are very important. That how the principle of international human rights law obliges states to grant citizenship to individuals who might have fallen in the cracks between the jus soli and jus sanguinis principle as well. That is something which we need to look at it, where people who are migrating on the move for employment reasons, for other reasons, persecution reasons also, they could be used. So as you said earlier, the statelessness can be also two front. One, the de jure statelessness and de facto statelessness. The de jure being the legal one, legally that you are not citizen, is what is formally counted. The de facto-ness becomes a situation, as we said earlier about the example of the West Pakistani refugees, when they were granted citizenship by the Union government, automatically the international obligation gets withdrawn. And they were entangled again, being unrecognized, and then between the Union government and the JNK, there was the tussle actually went on. It becomes a classic case of being de facto. Another point I just wanted to highlight is the de facto-ness again has a broader scope to look at variety of other groups who could be in a situation of practically being stateless. One may count a COVID victim, COVID labor migrant, and several other things to do. But what from the international regime, international lens, how they look at it is only if it is de jure statelessness, they formally want to look into that category and apply the international protection. If it is de facto-ness, they do not want to do so. Very precisely for this reason, the de facto stateless count is now going down, both by a formal sense by the UN bodies, civil society. We are trying to kind of keep the de facto away so that it doesn't give a situation of neither here nor there, and they want to clearly define if somebody legally stateless, that has to be addressed on a priority. But yet, from an academic point of view, practical point of view, stakeholders' point of view, one may look at the necessity to continue in this. One may look at again, from an access to justice framework, a variety of things where whether it's refugees or stateless people are most marginalized, more vulnerable, who face several barriers, impediments, could have all the things besides the respective conventions for refugees and stateless. You may have UDHR 1415, ICCPR Article 127, ICSCR Article 2. Similarly, the Sustainable Development Goal, which talks about inclusion and leave no one behind. That becomes again a framework where one can look at the scope for both refugees and stateless population. I'm skipping some of them straight away, and I want to conclude now by saying that from the perspective of gender neutrality, which we need to promote from a statelessness perspective, one may draw from SEDA Article 9 and CRC Article 217, where women, men enjoy, including rights to transmit the nationality to the children. I think this needs to be emphasized for those countries which have not yet made a gender neutral citizenship laws. There should not be discrimination on the basis of race, ethnicity, religion, disability. One can draw from the 1961 convention, one can say from Convention on Elimination of Racial Discrimination, Article 5, from the Convention on people with disability, Article 18, CRC 217. One can look at these a few examples. I'll just end with this. UNHCR has taken this as a campaign. UNHCR is having a position to end statelessness as an imperative in the contemporary times, which emanates from ethical imperative, rule of law and development perspective, and from peace building perspective. They look at it, and then they are trying to do a campaign from 14 to 24. They have gone a campaign. Now we've crossed mid plus in a way, and where are we? We do not know from Indian context at least whether we have made any progress in this statelessness. No, I would say rather we become more regressive by issues of NRC, CAA, and all that, which has come as a controversy to essentially bring in othering process, essentially bringing non-inclusion in the process is a big challenge. There are several questions I have. With that, I will end that. How do we look at the context? New borders formed due to the COVID pandemic, migrant laborers as a context we have. Are they treated as stateless people? Who governs the stateless people? There is a perpetual statelessness by authorities, easy to exploit and do a kind of labor exploitation. One may also look at the intersectionality of gender, caste, religion, and other fault lines which are there, very much connected with the citizen stateless binary. And how do we look at it from academia and civil society's point of view to do mapping exercise, to conduct research, what kind of scope to collaborate. All these are some of the things which we may have in terms of there is enormous scope to conduct exclusive research on child rights from the experience of statelessness. One may look at from denationalization process vis-a-vis NRC or CAA and do a lot of research and endeavor towards prevention of statelessness. One may look at from range of other perspectives from cutting across many theoretical research, legal, social, anthropological, and country of origin specific fieldwork perspectives to pursue how we can have better insights on this issue, which we are fairly clear on refugees, but the statelessness which is yet to emerge, in the formal sense of discourse and policy discussions, one may look at it and see the scope. So I'll end with by saying that there's a need for more of a postmodern sensibility, which can bring in multiplicity of methods in these kind of research methods in these kind of phenomenon, these kind of issues from multiple sides of contestation. One may look at it. Mere legality does not help us. In fact, legality combines with other discourses to form an individual as a locus of ever greater network of administrative control. I think that's where I want to end with this quote, that that kind of a challenge today we are having, that legality is a solution. I started with, but I'm ending by saying that by this very legal process we are also trying to do the othering process, trying to do a lot of exclusion. So therefore, I think a multidisciplinary perspective is needed to address statelessness, which is a very complex issue, which is deeply buried, which needs to be unearthed, and one has to, bring some kind of solution through multi-stakeholder approach. I think due to positive time, I'll just stop here. We have a little more case thing, but I will not go there in RC. I'll just stop here, and then I guess we have some time for discussion. Rather, I look forward to more of your comments and your questions, which will be very useful. Thank you for your patience. Now the floor is open for discussion.
Thank you very much, sir, for your lecture. I see around 7 questions in the chat box right now. The first question is from Shishir Tiwari. He asks, what do you think about the Supreme Court order of 8th April 2021 in the case of Muhammad Salimullah versus Union of India?
Very frankly, I have not very clearly followed this case in a very, very close quarters, but I'll make some general observation. Rather, if Shishir is there, would like to little more elaborate this case. Can he provide some insights?
Yes, sir, I can do. Yes, sir, in the context, what you have said that the Rohingyas do not pose any threat to the internal security. In that case, basically, Supreme Court has accepted what the government of India has argued in that case, that the Rohingyas are posing the internal threat to the security of India. And the Supreme Court has accepted that thing. On the basis of that, Supreme Court has allowed the deportation of Rohingya. So that was my point.
Yes, I think, these kind of cases, I think, becomes a kind of a silver lining in a way that, I think this person was residing at Jammu and Kashmir, I suppose, right?
Yeah, right. Correct. I
recall, I think Jammu, from there they were trying to deport him, and that's where the court, I think, came up with an intervention that, we need to also kind of apply the principle of non-refoulement.
Yes.
Somebody is there, even though we are not signatories formally, and that's where, sometimes government tries to push, whether it is in 1991, post Rajiv Gandhi assassination. A similar push happened for Sri Lankan refugees that they need to kind of go back to their country, and at the time again, this principle of non-refoulement came up, which is an important component. Today we call it as an important instrument of underneath the customary international law. That even if you are not signatory, that you need to kind of abide by it, you need to kind of implement it. I think that is the kind of principle, I suppose, was referred in this case, and that's how the remedy came, that if an individual is here, if they don't have any clear case of any criminal offense or any other thing, that why they need to be targeted. So therefore, one needs to look at these few cases as an example. Similarly, the other case of Chakmas NHRC versus state of Arunachal Pradesh again became an important thing where the right to life was invoked. So this, I think, judicial intervention becomes very useful, very important thing to address these kind of needs. That's how I look at it. So this is a very important case, which again protects people, that they should not be arbitrarily detained, they should not be arbitrarily deported.
The next question is from Suti Basu. He asks, how important is the distinction between de facto and de jure statelessness? Some argue that it is more important to emphasize de jure statelessness in order to depoliticize statelessness, which is already overdetermined by national and regional politics.
Yeah. So this de facto and de jure distinction, I think for a theoretical understanding, it is very useful. But I think, as I was saying earlier, that from the international human rights, international humanitarian intervention, from humanitarian perspective, particularly who is kind of taking care of the statelessness promotion among along with other stakeholders. We emphasize that if it is de jure, it becomes very clear-cut to link up the international law, international obligation. If it is de facto, it is a kind of within the nation state, when the nation state is recognized somebody as a citizen, they may have the de facto situation. For example, currently the labor migrants. The labor migrants, somebody would call them as almost that the state did not take care of them. They did not take care of their health. They did not take care of their travel, all that stuff. Where they have to suffer, and a lot of loss of lives also happened, not because of COVID, because of the long treks and other things. Now, one may invoke that it is also a situation of statelessness, but this has to be dealt in a different perspective. How do you look at them from a pandemic victim? How do you look at them from an IDP perspective? I would say that's much better than invoking de facto statelessness, because if you are putting de facto statelessness, then you are actually creating a confusion between those who are de jure stateless, who are without any kind of citizenship, any kind of rights, versus these kind of groups who may be citizens but may not have certain rights they enjoy. So therefore, of late, the discourse is also changing, that theoretically it's good to understand de jure statelessness, de facto statelessness, but in a practical sense, that it is better to focus on de jure statelessness as an exclusive category, rather than mixing up them with the de facto-ness.
Okay, the next question is from Shriparna Banerjee. She asks if the Rohingyas can be put into the category of de jure statelessness.
Yeah, they are de jure stateless from the country of origin perspective. That they are straightaway persecuted, discriminated, and they are denied of their nationality. Quite many of them, Rohingyas. That's the reason that they are fleeing and coming in. But today, I think the narrative is also changing with the intervention of United Nations and the kind of pressure on Myanmar. Today, Myanmar says that Rohingyas are welcome to come back, and then they would get their due process and recognition and all that stuff. They are giving on paper at least. But in a first place, that they have been denied as per their nationality laws changes which they have brought in the 80s, and then what they started invoking in the last 10 years, 15 years. I think very clearly they denied them in the first place, and then they are, of course, as we said earlier, that they were stateless in the first place, and then they're fleeing as stateless refugees to other countries. So that makes again a very complex thing. That how do you bring them under the refugee pure refugee gambit, or is it through statelessness gambit, or is it a combination of both? That again makes it very complex for many country of arrival, where the countries are receiving them. It makes it very complex. Because there is also a notion that somebody is a citizen of some country only with the temporary reasons of persecution, human rights violation. It is assumed that they are coming to another country, and it is that temporary nature that one tries to invoke, that they are there for a short-term protection, and then they would return. But if they're coming with the priori situation of being stripped of their citizenship, that makes all the more complex when they enter. And therefore, then it actually compounds the problem for the recipient countries.
Okay, we have a question from Sucharita Sengupta.
Yeah, thank you so much, Parivelan. I mean, it's always so good to listen to you. So, I was actually wondering when you, in the beginning of the lecture, when you were asking about categories and you even mentioned it now. So, protracted statelessness also leads to refugeehood. So if you consider the case of Rohingyas living inside Myanmar, their living conditions are that of, that embodies refugeehood in a certain way, and they are also being termed as refugees. So my question is, how are these categories self-explanatory? We of course need them, but how much they are able to capture the differences? And drawing from there, the second is, how is the difference between a stateless person living in a camp like that of a refugee? So if you consider the camps in Bangladesh, and like vis-a-vis the living condition of a refugee who is not a stateless person, so how are their daily living conditions different? So basically, I don't know whether I could articulate my concern properly, but my question is, how far can we actually draw a distinction between a refugee who has been living a life of, like protracted refugeehood, and also a stateless person who is living a life of a refugee? So how far can we actually capture these differences through their living conditions?
Yeah, it's actually, thank you, Sucharita. It's an interesting question. How do we kind of understand, these kind of, labeling and looking at the categories, the conditions, which are often, sometimes these labels also keep changing. If I may just take one example. When the conflict breaks out in Sri Lanka, ethnic conflict, somebody may be initially called IDP because they have just got affected. Let's say, Batikola, they got affected, they moved to Jaffna, or from Jaffna, they moved to another place. So they're IDP. The moment they catch a boat and come to India, they get the label of a refugee. Now, from a refugee status, they again return to their country, they become a returnee, but yet may not be in the place of origin, but somewhere else. So again, a returnee, but a displaced. But again, they reach their place, they may settle down as somebody who's returned and become a citizen again. Could again be attacked by the spiral of conflict situation, could again get displaced, again flee. So this cycle movement actually happens. So that makes it very complex in one sense. This also answers partly when you say that even if you take Rohingya as an example, that in the first place that they are stripped of their citizenship, then they are told that you don't belong here. So they become stateless people. But yet they can be internally displaced, that they are, from an international law perspective, this labeling definition also becomes very important, how they would like to, look at it. As I said earlier, this is where we also sort of need to engage a little more post-colonial, research and engagement to bring more nuanced terminologies, terms which can accommodate our cultural, our geographical nuances also. This is one aspect of it, but nevertheless, the international law, but nevertheless tries to provide that uniform international universal standards in which they would like to label and look at what are the needs. So automatically, somebody is a stateless, then they go to the 5461 convention, somebody is a refugee, they go to 5167 convention. Sometimes it could be combined also, as we said, that, all that stuff. But in a situation, for example, if a Rohingya is affected, stripped of their citizenship, being affected, if they don't cross their international border from an international law perspective, they can never become a refugee. They can only be a protracted IDP, a displaced person, and probably a stateless IDP. That sort of a thing which we need to see. Coming to Bangladesh, if same Rohingya had lived for a very long, they're definitely stateless refugee. And their prolonged stay, how one should ensure that their right to return is not taken away with a conducive, quote unquote, conducive environment. That's very important. A refugee can never be pushed back without their will or consent. That's something very important, that they go on appropriate time and a conducive nature that they could return. Then they become many returnees than settle. So therefore, these tags, labelings, from certain international law, international perspective are at times very important. But therefore, then the respective international law and other conventions would be invoked, and there could be protection. Sometimes, you have the borders, movements, migrations here could be quite complex. Therefore, that also one needs to take into account our local conditions. But definitely one may, certainly differentiate between an economic migrant and a refugee. That we very clearly do. Again, in South Asia, CRG alone has done a lot of studies on mixed migration, mixed and massive, the term used by CRG, again brings a lot of nuances which may not be captured by the 51 Convention or other thing that is also taken into consideration. And also, there was, I think, an important debate and discussion between UNHCR and CRG on bringing different categories and groups which can be brought in, which cannot be brought in. Also, I think brought in a little bit of debate on de jure and de facto nature. I think so. And therefore, that is also a fluid area again that one needs to see, not all the times only from a pure international law lens, but also from local context and nuances have to be taken on board.
Next, we have a question from Sriraj Gudi.
My question is that how that India doesn't have a specific defined policy with respect to addressing the refugee matters. How far this situation, the absence of a policy, has helped the government with respect to addressing the case-by-case method, or whether it hindered the process of addressing the issues related to refugees?
Okay. If I can get your question correct, with this kind of ad hoc approach, does India benefit or does it do an effective refugee protection? That's what you're saying, I suppose, right?
Yes, sir. Yes, sir.
Yeah. So in this context, one can say that from India's point of view, having a culture of hospitality, culture of care, compassion, which has been rooted in our culture, forms the basis, and that's where we had seen that kind of a culture and tradition of caring for people. But I think our post-colonial nation-state formation, boundary making had made us become more rigid, naming somebody as West Pakistani, East Pakistani, or a Sri Lankan, and all that stuff became more rigid in the last few decades. Having becoming born as a nation-state with our constitution and our functioning, I think geopolitics also plays, I think, a very important role. If you look at how we welcomed Tibetans to a larger extent, to some extent the Sri Lankans, but I think other groups we have always had reservation. But as you rightly use the word, we have been having a piecemeal approach, kind of, very selectively we are treating different groups in a different way. From an international law, international human rights, international humanitarian protection point of view, this becomes definitely very problematic. As I use the words of Professor Chimney, that we need to shift from this charity approach to more of legal-based approach to exercises. Therefore, that is one aspect of it, that we need to legally have a proper, if not signing the convention, at least legislation, and a very clarity on defining, because none of our laws, whether it's constitution or our criminal laws, none of these places we have the term refugee defined anywhere. We always bring the Foreigners Act, we always bring in the Passport Act, and then we always bring in a kind of illegality. That anybody would migrate, it wouldn't have come in a formal sense. So always any person, whether it's a Sri Lankan coming in, whether it is a Rohingya coming in, there is always an illegality attached to it. Therefore, they are, put into a disadvantage where they cannot get into any other formal naturalization process. I think this has to be addressed definitely at one level, and then that uniformity, what we can call, I'm expanding your question into a larger thing where we need a proper mobility law. The mobility law would address various facets of migration: the economic migrants, the students who want to come and study, the people who want to come on a short-term visit, people who are persecuted wanting protection, Today, our border security forces, the coastal guards don't have any framework, and it is at their mercy that they treat people or ill-treat people, and already persecuted people suffer several fold in this kind of transit and migration. So I think if you have a law, you can bring them, screen them, test them, you want to protect them, and then you facilitate their return, you do it as per the norms. But today we have all these flux happens because there's no clarity, there's no clear legal prism, which is not able to connect with socio-political realities. So I started with geopolitics, and I'm ending with what we need is a kind of, I think, a humanitarian canvas, humanitarian framework, which has been there in our history and culture, which needs to be invoked. And there are a lot of paranoia again, xenophobia again, that fear for outsiders, that these people will come and affect our demography and things like that are also being talked about. But if there is a law, if there is a clarity, who can be taken, how it can be taken, I think there are a lot of other issues will get solved. Issues like porous borders, issues like who can come in, who cannot come in. But today what is happening is because of the lack of proper clarity, a law or a framework or a policy, today you have all the unwanted people are also entering. People who are genuine are suffering, who needs international protection, who needs that kind of a burden responsibility sharing mechanism gets negated. But you have the unwanted who enter because of lack of clear-cut legal framework connected with proper law and policies.
Thank you, sir. We now have a question from Joy Karmakar about the effect that refugee populations can have on the demographies of small countries.
Yes, so I have two questions. So one is regarding from the small country perspective. So, sir, you have shown a large number of refugee numbers, so in millions. So there are small countries which have some million population. So if these large number of million populations enter into a small country, so these countries, the demography can easily change. So my question is there any provisions under UNHCR regarding the protection of the interest of the small country or the small ethnic group which is there? And the second question is, all refugees can apply for asylum in any country? Thank you.
Yeah. Whether I'll start with the second question, whether all refugees are eligible to apply? Yes, refugees anywhere been affected, displaced, have a right to apply, seek asylum, seek protection. But that becomes, too larger a thing that as if they have right and then they claim it. Then everything goes through a kind of an RST process where, for example, a Sri Lankan refugee had entered India. Now, in the first place, that automatically there is a process where they have done some screening at Mandapam camp, for example. I have briefly worked with the Sri Lankan refugees earlier. Therefore, I'm saying there is a camp located close to Rameshwaram district. This is the arrival point. They're screened and then they're taken into a refugee camp. Then once they get a card, they get the status. That's how the government of India, both the union and state government, do this process. And there are certain range of benefits by this qualification. They would get a shelter, and then certain dole they get, some vessels, some clothing, and the children can avail their education, hospital. All these are covered in a way. That's something I'm just sharing as an example of somebody coming in and getting. Now, the same refugee wants to now apply to another country. It's called third country resettlement. So for that process, they need to kind of apply to that country. If there is an invitation from that country, then they can take the help of UNHCR, get a certificate, and then go for a third country resettlement. So therefore, that question I'm answering, that the refugee can apply. Yes, any XY country, they can apply. I mean, they want to, if it is accepted, then they can go. But normally it is very difficult. I tell you, for Sri Lankan refugees' point of view, what we have seen is only if they have their relatives living in Australia or Canada or UK or US, that if their relatives are there, they sponsor them, then they try to say that they can accept them. It is only through that it is there. Now, an ex-refugee can apply any country they want, but 99.9% they may not get it. That's a restriction in a way you have. Now, I'm coming to the first question. What about smaller countries and burden we're talking about? Yes, it's very, very important to look at how smaller countries like sometimes, the Syrian conflict, the neighboring countries of like Jordan, a very small country, which could take so many number of people. Even if you look at the Afghanistan crisis or Iran crisis, Pakistan had been taking relatively smaller country, but taken the largest number of refugees. And recently it had a status of the largest number of refugees in a country. One year recently, Turkey took over. So you have these kind of smaller countries hosting larger number of refugees, and it becomes quite complex and problematic in terms of demography. Definitely, I think there the notion of responsibility sharing is very important. I'm trying to bring in the New York Declaration and the Global Refugee Compact. The Global Refugee Compact does address these things, for both Refugee Compact for refugee, a global compact for migrants. Both are trying to address that the host country should be enabled, and some kind of a support from international community should be there in terms of resources. Sometimes you look at Rohingya example in Bangladesh. Now Bangladesh couldn't actually take it more than this kind of million plus people, but it is only because of the international community, particularly the UN and other agencies have gone in and they are providing a lot of material resource support. And they are able to kind of address that. If Bangladesh alone, without any external support to handle, Bangladesh would have collapsed a long, long back. But that also has a limit. How much international support can come in, how much that can be carried out. So I think that it all comes under the notion of responsibility sharing. Earlier it was called as burden sharing, or you can call it burden and responsibility sharing notion, that this is actually worked out how a host country can take how much load, and otherwise it has to be distributed automatically to other countries. This is the norm. This is the kind of normativeness fixed there. But sometimes there are other countries who do not come forward. The burden is excessively on one particular country. Also happens in the smaller countries, then it becomes quite challenging. So it has to be addressed in terms of distribution.
Thank you, sir. Darshana now has a question about discriminatory citizenship laws and how international human rights law may look at that matter.
Yes, thank you. So my question is basically, given that statelessness is often a product of discriminatory citizenship laws, and obviously citizenship laws are seen as the last domain of sovereignty, how effective are principles of international human rights law in addressing discrimination in national citizenship laws?
See, as I was talking in the very beginning, that we do have a kind of colonial hangover. We do have a problem of bringing in a Westphalian model of European experience into our nation-state formation are all problematic. The politics and culture being mismatched is problematic. But having said that, the constitution making, the law framing vis-a-vis citizenship is all exclusive domain of the nation state. The sovereign nation state it cannot of course bring in any discriminatory law in contravening to the international human rights framework, UDHR or ICCPR and all that definitely is there. But a country can definitely frame the law, it can. But it has to ensure that it is able to do it in the framework of rule of law. That has to be also there. Now, for example, within our own Indian experience, that we are also trying to do an aberration. We are trying to kind of, bringing in CAA, for example. Now, CAA is a very clear-cut case, in my point of view, a very clear-cut case of discriminatory law. You're trying to say that you're accommodating people from the three neighbors, Pakistan, Afghanistan, Bangladesh. The minorities who are to be persecuted, you're assuming, and then you're saying that only they are welcome. So you're excluding the Muslim population very, very clearly, assuming that the Muslim majority may not be persecuted. That premises is also wrong. You may, even a majority from these three countries, which are Muslim-dominated countries, will also be persecuted and they may require protection. In other words, again, those who, you cannot again, very clearly we have in our constitution, fundamental rights, the golden triangle, article 14, 19, 21. All three are very important. It gets affected by these kind of, discriminatory CAA. So the CAA is very clearly kind of having religious minority bias. It is very clearly saying that it will not accommodate a particular group section. I mean, at least when it came, even in 2016 as a draft, later on in 19 it came, had another question as well, that why are we creating a limitation to our neighbors only these three countries? Why not Sri Lanka, where a lot of Indian origin people, in fact, suffered, and a lot of back and forth challenges we faced addressing statelessness, addressing citizenship and all. Why we did not bring in? Why we did not bring in even our neighboring Myanmar, which is a kind of border of South Asia and Southeast Asia. Why we are excluding? We could have brought in Myanmar. After all, we share a direct border with them. So all this actually becomes a question. Therefore, in my point of view, I think we cannot have a discriminatory law. That is the reason why UN Human Rights Council chief had filed a case in Indian court. Right away, she had filed a court that that CAA she has challenged. They wrote a petition. They wrote complaints. When they did not get any response properly, they have filed a formal complaint. So there are a lot of other people who have also challenged it in the court. So it is actually a kind of a law which has got several loopholes, and therefore it is contested in the rightful manner. I would say we need to, I think, broad base it. You may have your intent, but it is also excluding very clearly, and that intent cannot be then accepted.
Thank you, sir. We have another question on the Citizenship Amendment Act. Lam Sithu, does this previous answer your question, or do you have anything specific to raise, which was not answered by the earlier?
Yeah, sir has kind of answered my questions, but I just wanted to give it more clarity regarding the Citizenship Amendment Act 2019, because as he clearly said that it denied the citizenship rights to the Muslim communities. So in this case, also have seen that there is the Rohingyas refugees are detained in Jammu and Kashmir, and then they also face the charge of deportation. So what I wanted to ask, sir, is do you see that deportation is the only way out, or is the only way for the Indian government, since the Rohingyas will never be eligible for the citizenship as per the Citizenship Act of 2019? So in that case, they have to be deported back. So in the scenario of them facing the deportation, is there any international law or that India is a signatory to it, where international community or international law has the right to question on the Indian government? Is there any legal aspects on that? That is my first question. My second question is, since India has followed the age-old policy of humanitarian approach or ad hoc approach that we always call it, do you see that since 2014 of the NDA government, do you still see that we still follow the same old policy of humanitarian approach, or do you see that there is being a certain kind of clarity on the Indian government? Because as I see, the Citizenship Amendment Act has kind of give us some direction that Indian government is more clarity on whom they want the citizenship to be. So that's my second point. And my third point is, since South Asia is the region of refugee producing country, so I think there should be a responsibility for every state to share the burden, the responsibility of sharing the burden. So in that case, SAC also sometimes talks about adopting the regional framework. So do you see SAC taking an active role in adopting the regional framework on the refugees, as in the legal aspects in that case? Yeah, that's all my question. Thank you, sir.
Okay. Thank you for the very elaborate multiple questions. I'll try to synthesize and time positive, try to quickly address them. I think the first thing about the CAA and the Rohingyas. See, now it's not because that the Rohingyas may not qualify to become a citizen, therefore then they need to be evicted or thrown out. No. But the point is, if somebody is persecuted in some country, the fact that they are fearing for their life, as per the 51 Convention, itself that they are discriminated, they are ill-treated, they have a right to seek refugee in another country. So therefore, if Rohingyas have come to Bangladesh or India, the fact is that we need to provide them that interim protection, interim support, to make them survive, to safeguard their life, right to life, and then provide whatever is possible. That's something very important. Even if India is not signatory to the 51 Convention, it is actually obliged, as I said earlier, by the principle of non-refoulement. The French word non-refoulement in English, non-refoulement in French. The non-refoulement means that nobody should be forcefully sent out of the country the moment they entered for protection in the country. So that has become now a customary law, customary international law, that you are obliged even if you are not signatory. So that principle very much applies, so that you can't forcefully expel them. For example, Rohingya is fleeing for life, that they are fleeing and coming into India. And India picks them and says, right away you go to your country, and then they die. What happens? Then obviously you are responsible, right? That's simply, I'm putting in a very blunt way. That is the basic principle, that life should never be risked. So provide them protection for the period. So that's a norm. Now the burden sharing also, or the responsibility sharing, to be more politically correct, becomes very important. That if the numbers are high, it will also be distributed across countries. Then international agencies, international UN body and others need to come and provide that due support. So that sort of a thing will automatically take care of things. So therefore, that's about the thing about the no Rohingya, because they don't qualify to become a citizen, not to be pushed out. Every refugee in the first place has not come to your country to seek citizenship. They seek protection and come to your country. Therefore, you protect them. Even today, if you look at the Sri Lankan numbers, since I handled it pretty closely, more than 4.5 lakh people, 4.5 lakh people have come in different times from 1980. But today, post 2009, conflict got over, and many of them have returned. Today, you have roughly only 60,000 people in the camp and around 30,000 or so outside the camp. So put together, approximately 90,000 to 1 lakh only are remaining, wanting some clarity to return. Otherwise, others have all returned or resettled to other countries. That movement has happened. Similarly, Rohingya, what we are saying is that take their numbers, give them some identity, give them some protection, take care of them. And India is the best country to do the humanitarian diplomacy. Talk to Myanmar and then send them at the right time. The matter is over. You don't need to keep them as a burden forever or anything else. That's one thing. Number two, the question on whether human rights, humanitarian law, there are any changes post 2014. I think international law, since we did not have any major development, we did not remove any big law. We did not, but there are a lot of domestic laws, a range of them controversial, ranging from cow protection, beef ban, abrogation of Article 317, things like that. We have done internally our domestic law changes, tweaking, all that stuff, which are also a matter of concern, because we are essentially we are having a ethos of secularism. As a secular country and multicultural protection country, we cannot bring any law which will affect any minority or anybody. But I think the attempt done through CAA and these kind of stuff again are, I think, being questioned very much. India, how much ever can say that we have our own domestic interest, we have our own priorities and all that. But as per the constitution, which will take care of people of equal treatment for all, cutting across, culture, caste, every other gender, every other thing. So we cannot have a discriminatory law. We cannot do so. But so therefore, I did not see any international humanitarian law, human rights law, any big changes. But rather, I think the international community is pushing India to as a growing power, in the region. It is saying that you need to also conform to some of the international standards, international law. I think that pressure is very much there on India. Thirdly, coming to South Asia, I agree with you that yes, the South Asian countries are producing and hosting, and therefore we need to have our own burden sharing formula clarity. To be more specific, one example, I think earlier under the aegis of SARC, South Asian Association of Regional Cooperation, we did attempt a model SARC law on refugee protection. Justice Bhagwati and others were very much behind it to push for this thing. Unfortunately, this did not take steam much within the SARC. As we know that SARC, we are very much divided thing in the sense that it did not come through. But at some point or other, I personally believe that SARC should take it up as my personal opinion, and I agree with you that we should have a framework on which we will cooperate, protect, all should happen. Otherwise, what happens is that there is again a notion that India is a victim, that India is not producing much refugees outside one's country. So it assumes that the neighborhoods are all very unstable, whether it's Sri Lanka, ethnic conflict for a very long number of years, Pakistan, a number of presidents rule and political instabilities in the past. Bangladesh has always been very crisis-ridden. Nepal is always crisis-ridden, whether it is during the earlier rule, the king's rule, or now the transition to democracy. There is always political. So this political instability is quoted by India to look at from its national interest point of view, that this unstable neighborhood is problematic if you open the door too much. Therefore, India does not want to take any lead and all that. But I would argue the other way, that all the more there are instabilities and need for international protection, we should open the door for those genuine few and ensure that we will protect them and then facilitate their return. Is a genuine human rights centric approach of a nation state which wants to play a global or a regional role. I would argue from that point of view, we should in fact keep it open.
Thank you very much, sir. So we have 3 more brief single point questions. Shonali Narang, will you please unmute and ask your question?
Greetings from Vadodara, Parivelan University. Good to see you, and it was very good presentation. So I would like to ask you that, like the people who have been displaced, like for example, from earthquake or from natural disaster, people documents get lost. So what's the mechanism that state follow in that regard to extend statelessness status or to determine the citizenship? Like so many people do not have documents, or sometimes their documents are being stolen, or they do not have. So is there any mechanism? One question. Second question, is there any country which genuinely on humanitarian grounds is addressing all the problems related to refugees, statelessness, or showing solidarity towards this problem of refugee? That's it. Thank you.
Thank you, Kunali, for these 2 questions. First question is on natural disasters or calamities or losing a document. See, losing a document, a person does not become stateless. In a very theoretical sense, I'm saying that you are carrying your passport. By virtue of losing the passport, you don't become a stateless person. You can automatically go create a duplicate document, and on a due process, when you are traveling abroad or within the country, you can create your document, and you have other things essentially there to do so. But yes, it is also a matter of issue when it comes to large-scale calamities. For example, Assam and NRC time, this issue was debated actually, that many parts of Assam are having regular floodings, and therefore there are a lot of people who are constantly on movement, constantly being forcefully displayed. Therefore, they lose their documents. How do they come and show a document? Do a scrutiny process like NRC. NRC essentially had a list of documents to be produced, and therefore they have to do it to show that they are, citizens of India within that whatever cutoff period of all that stuff. Therefore, it became quite challenging. But I think there are again avenues in which they can go and generate their document, and that they can do. By virtue of losing a document, you don't become a stateless person in the theoretical sense. But in the practical sense, yes, large-scale calamity, large-scale earthquake, large-scale tsunami, large-scale flooding can affect people, and people were quite disturbed over this aspect. And therefore, it has to have a more humane approach. If you look at our national disaster management policy, it is still an evolving one. We have a Disaster Management Act 2005, which gives a range of powers to national disaster management authorities, state disaster management authorities, district disaster management authorities, up to a local panchayat or an urban body. Till there, you have a range of powers being distributed. And I think we are yet to kind of give a full swing powers to them and see what they can do to address these kind of issues, documentation or even relief, rehabilitation. Even recently, the Supreme Court had pulled the National Disaster Management Authority on the very pandemic victims, ex gratia payment to the deaths which have occurred. It said that why you are not drafted any guideline. I think now NDMA is working on it. having briefly interfaced with the NDMA, I could say that there is an enormous potential for this kind of a body as a legal institution mechanism. And I think they can take care of a lot in terms of this documentation, other legal, socio-legal processes. I think it can be done. Coming to a second question on what is there any kind of a model country? I don't think there is any model country, but there are only countries which are signatory to the conventions like Statelessness Convention or Refugee Convention, countries which are not and adopting different combination methods. That's how we have. But we can name, for example, since you said name any country, one can look at Canada as an ideal example. Canada, of course, has a very liberal immigration policy. Canada accommodates a lot of refugees. I know if one goes to places like, there are, eastern part of Canada, you would see so many Sri Lankan Tamil refugees all are settled down. They are almost Toronto. So they have almost have bazaars, which are not just mini India, but mini Sri Lanka, you can say. So you have a lot of hubs where these kind of things have happened. Again, if you look at Europe, under Angela Merkel's regime, I think it had been very progressive from this crisis from West Asia and accommodated a lot of people affected, displaced. Germany is a good example, I would say, for bringing a lot of accommodative policies. So you have few countries, only very handful or very few we can name, which are accommodative, which are progressive. But there are many countries which were earlier liberal, but today become very rigid. I will name Australia in that negative category, which was liberal earlier, but today it has created some islands like Christmas Island and other things, exclusively to bring people to screen them outside their territorial jurisdiction, which is very, very regressive. I think recently, even I think some European countries, if I'm not wrong, even UK, I think brought in some kind of a rule like that. So they're trying to kind of, essentially, there are many countries which are closing the doors and trying to keep, their jurisdictions outside their territorial borders so that they are not obliged to answer anybody. So I think this is a regressive trend which is emerging in a way in a post 9/11 type of syndrome or paradigm shift underneath the quote unquote national security parameter. I think that's very problematic.
Okay, thank you, sir. Sheikh Rafiqullah, briefly, please.
Good evening, sir. It was indeed a very good lecture. I got to learn so many things from the lecture. So, my question is like, you explain about refugees, the numbers of refugees today in the world, and the geography from where they come. Has there been any studies, or is there any data specifically on this issue?
Is there any religion-specific data on the status of
yes.
Okay. This disaggregation of data, I don't know whether it is applicable, but I can answer it in a different sense. That somebody is a victim is seen in a very, very neutral sense from a humanitarian principles point of view, whether it's UNHCR, whether it is ICRC, or other civil society bodies. They always have one principle to see beyond religion or race or other, any other distinction. That's a fundamental principle that anybody is a victim, and the moment they are refugees, they come under the gambit of international, humanitarian, human rights, and refugee protection angle. Normally, we don't, disaggregate, but this data is, I think, possible. It is actually possible for any other better and effective way you want to manage. It may be possible disaggregation. But normally what I had seen is, for example, having worked a little mostly on the ground with Sri Lankan refugees, I have never come across any, segregation of any Hindus, Christians, Muslims of that sort. I never seen that in the count in the government data or UNHCR data like that. I have not seen it actually because of the fact that we are not supposed to discriminate. Any intervention, any response have to have a kind of neutrality, have to have everybody on board. Even if it is a natural calamity, even if somebody is a refugee, one cannot have a pick and choose model. There are certain, guidelines which are available It specifies that you can't discriminate anybody on the grounds of race, religion, ethnicity, culture. You have to treat all of them equally. That's how the humanitarian organizations also get a go ahead.
So I just want to elaborate, sir. I had this question. This may not be useful, but in recent times we have learned that the states like our own country, like India, they don't want to take Muslims. Like this, if we take this act or the Rohingyas, India doesn't want to take Muslim people back into the country. So it's very important to know religion-specific data, and so that we can learn why states hate a particular religion.
Actually, it's a double-edged sword. As I said earlier, if you have a data, you will have more nuanced understanding of their marginality, their vulnerability. I said it's a double-edged sword. The other side is that can be used by the very state to discriminate, or any other agency as well. So therefore, one has to be very cautious. There's no problem, or there is nothing wrong in having that kind of a disaggregation and having a clarity, because we also have an equity approach when we are doing any response, any kind of protection, any kind of care. Therefore, for the equity approach, if you know somebody is very vulnerable, you can, of course, do it. But what happens in a larger sense is that, for example, the people who are Rohingyas, there can be also Hindu Rohingya, but there will be very minuscule. But they're largely Rohingyas are identified with religion. The Rohingyas are essentially Muslim. Essentially, they are a distinct cultural, ethnic grouping, religious grouping. That's how they're branded. For that very reason, today we understood how Rohingyas are the most persecuted, most vulnerable people in the world. That therefore gets certain priority in terms of protecting them. But nation states can also use it to kind of push them back, not to allow them, not to accept them, which is happening in India, which is very unfortunate. The Rohingyas are not wanted in India, which is very unfortunate, very wrong policy. We need to extend our arms with open, impartial, humanitarian approach in a very normative sense, not to go by it. But all the, as I said earlier, the humanitarian laws, humanitarian principles are all supposed to be very neutral and supposed to take care of everybody equally who are in need of it. So that has to be there. But I agree with you that for equity approach, for protection, one can always disaggregate that kind of an information, and accordingly one can protect as well.
Thank you, sir. Thank you, sir. We move to our last question for the day. Shriparna Banerjee, can you please be very, very brief?
Yeah, I can be pretty brief, and thank you, Parivelan. I think the presentation was very, very good. So since you touched upon the SDG goal 16, so I just had this question in mind that the SDGs exhort the global community to leave no one behind. But however, there are no international rules or measures in place to ensure that the refugees are integrated in national development policies or plans. So how can this be addressed? Is there any way to address such a thing?
See, when we look at these sustainable development goals as a framework, as a continuation of MDGs, development goals, if you look at the essence of it, it doesn't say that it is for citizens, it is for national, for the citizens of a particular nation state or anything like that. It is a very universal framework where the nation states have adopted, and they have, mainstreamed that in their developmental, policies and practices. That's why we have a Niti Aayog, which streamlines ministries and departments and exercises it actually. Now, looking at, so therefore it is universal. It does not say per se that it is only for citizens, it's not for outsiders. But the nation states, it's up to them how they want to go about it. What I had seen from my observations is that bodies like UN, in fact, emphasize that it should be for all people, citizens as well as refugees and any other outsiders as well. Now, let's take an example of COVID. Now, if you want to do COVID vaccination, can you say that the COVID vaccination is only for citizens? It may also imply like that. Those who have Aadhaar or those who have all that, whatever apps related and all that stuff, one may say at one level. But on a practical level, I'm asking a rhetorical question. Can we exclude refugees and other migrants and say that only I'm going to give for citizens? Of the fact that the COVID will, in fact, affect people who are not given those jabs. So we have to give it uniformly, universally to all. In a similar way, SDG also emphasizes that you can't leave people behind and say that I'm going to develop other people. According to needs, according to priority, according to equity, you have to address. Therefore, it is very much important imperative that SDG encompasses that. I had seen at least UNHCR a couple of times my visit to Delhi and attending some of the consultation meetings and other things. They very much were emphasizing that SDGs are getting promoted in the government of India. They're ensuring that all the refugees get all the basic needs, necessities. But that again, because of our lack of uniform policy, we don't have any fund allocation. We don't have clearly for all refugees. For Sri Lankan refugees, we have some fund allocation. For Tibetans, we have kind of a land allocation. For other people, we have others. So that because of our piecemeal approach and differences, the impact can differ. But I can say this, that when it comes to things like COVID vaccine or something like that, you can't leave a refugee and stateless person and say that I'm going to give only for citizens, where you're actually going to put yourself at risk. Therefore, I would say as a part of our policy, whatever ad hoc policy, that has to be made more uniform, and we need to ensure that SDG kind of goals are very much connected with protection care as well. But it's of course very challenging for non-signatory countries, I do agree. But I've seen practically UNHCR officially promotes SDG across the world and in all countries, including in New Delhi. I've seen them doing that campaign of SDG for refugees.
Okay. Thank you very much, sir. We are very grateful for the lecture and for the elaborate class participation that we have had today. Samantha, would you like to say something before we close?
Not really. Thank you so much, Parivelan, for your continuing support to everything that CRG does. And thank you for also taking the time to explain in detail all the questions that were asked by the participants. Thank you, Anand, for hosting the meeting. And also, as usual, thanks to our funders, IWM and RLS and other institutes and universities in India for enabling us to keep on working on our ongoing program on migration and forced migration studies. So yeah, I think we can end it here. Thank you so much.
It was a pleasure joining. All the best to all the participants. I also wish to attend few sessions I requested, so I'll be there around also. We will be in touch. All the best to the organizing team as well as participants.
Thanks, Parivelan, for being there.
Yes. All the known faces are coming out now. Yes. If I did see you in the list.
No, I just wanted to be part of it. Yeah. Nice to be there also.
I'll be also there around actually. Yes.
Yeah.
Interacting. Thank you. Thank you for.
Thank you very much, sir. Thank you.